Hello guys, in this session I'm going to talk about a very controversial topic, that how Miss Pooja Khedkar is going to get her IAS back. So UPSC have taken action against her, MHA have taken action against her, and she has been discharged from the service. Her candidature has been cancelled by UPSC. All these things are there. I know, you know, and everyone know, and no one is expecting that she will be reinstated. And this is not at all expected by anyone, but that's the fact. I can bet with anything that I have at this point of time that 100% she will be getting it back if there is a constitution, and if there is rule of law, and if our country is based on rule of law, and if there is a Supreme Court who is a watchdog of the constitution. I can bet on it, and I'm going to prove it with the facts. Okay, so I'm not going to talk randomly. I'll be discussing everything with the facts. I'll be discussing everything with the rules that we have. So there are certain things that you need to understand. I'll go through everything. See, what I want to tell you is whatever action has been taken now, which is completely illegal, and what the court will do is court will strike it down. Okay, so she will be reinstated, and that is what actually going to happen. But if these actions are taken in a different way, the court won't have any such opportunity to interfere. So at this point of time, there will be a judicial intervention, that's for sure, because of certain rules and because of certain reason, and that judicial interference will ultimately lead to quashing of these orders, and eventually she'll get back into service, and the court will tell that you follow the right procedures, and then whatever you want you can do that. So if they have taken this action by following the exact rules, then the court wouldn't have any such opportunity. But now 100% this order will be quashed. So that's my point. And to understand this, see, you might have heard some newses. Even the news, that's not correct actually. Even if you see the news, they are using the word Pooja Khedkar is actually dismissed, right? But what's the order? Order is actually about discharge. There is a huge difference between discharge and dismiss. Okay, now what Pooja need to do is, if she need to get back into service, only thing she need to prove is she is dismissed and not discharged. So there is a huge technical difference. I'll come to you. So only thing that she need to prove in the court is she is removed from service or she is dismissed without following certain rules and procedures. Now this discharge, there are certain other provisions, and if you look into the orders and everything, it is discharge. But if you look into the news and everything, it is dismiss. That itself is enough for her to get back, because there is another word which you need to know here, that is something called as stigma. So just keep these points in mind. I'll be coming to that. I have a beautiful PPT. So keep in mind the word stigma. Okay, so is there any stigma attached with this? And one more point that you need to keep in mind, that is there any inquiry related to a specific incident here? Is there any specific reason? Yes, there is specific reason. It's not about general suitability. So there is a difference between a probationer is discharged on a general suitability, and there is a difference between a probationer is discharged on a specific allegation. Here there is a specific allegation on a specific misconduct which can lead to stigma, and it's a kind of punishment. So what she need to prove in the court, these three words, whether stigma is there, 100% stigma is there, that the kind of publicity and everything which has been happened in media, stigma is there. So there is no doubt about this. Okay, is it a kind of punishment, or is there any allegation of a misconduct? Yes, right? Then it is actually a dismissal or removal from service, and it's not a discharge. I'll come to all of these. I have hundreds of cases. Guys, I'm a consultant in this field. So many people from state service, central service, all India service used to consult with me, and I know complete of this, even hundreds of judgments are there. I'll be talking about 7-judge judgment, a landmark judgment, Purushottam Lal Dingra. I'll also be talking about Shamsher Singh, which is again a landmark judgment. That is also a 7-judge bench. Okay, so hundreds of judgment I can give you. I can give you a judgment on the case of an IPS officer, Anup Jaiswal versus Union of India, VK Singh versus Union of India, Mahavir Singhvi versus Union of India. Mahavir Singhvi, that's an IFS officer. VK Singh, IAS officer. Same rule is applicable for her also. Okay, so what I want you to understand is, if she can prove in the court that it's a dismissal and not a discharge, or it's a removal and not a discharge. It's not a discharge. It's clearly based on specific allegation of misconduct. It's clearly having stigma. She cannot, you see, if she is telling the court that they have not followed the procedure, they have not given opportunity to defend, so natural justice is not complied. Now again, next word, natural justice. Okay, also another word, Article 311(2) of Constitution. So there are many judgments. The two landmark judgments are Purushottam Lal Dhingra and Shamsher Singh. Apart from that, IAS officer case VK Singh, IPS officer case Anup Jaiswal, they all directly comes under the same probation rules. IFS officer Mahavir Singhvi. Even there is a case of an SBI officer, Palak Modi versus State Bank of India. That case, he was accused of malpractice in an exam in which he cleared and he got the job. So he got the job due to a malpractice. That's the finding. But what happened? He was removed and he is reinstated. Okay, and that too by a very famous judge, and it's a very famous judgment also because of this nature, specific incident. There are certain procedures need to be followed. When it comes to IAS, IPS probationers, that's very strong. So let's get into this. Now keep in mind, all what Pooja need to prove is there is stigma attached with her because of this illegal termination. It's illegal termination because the rules are different. When she joined in the service, the rules given are different. Yes, of course, she might have done something, but it need to be proved. Is it proved anywhere? Now, they can prove it, of course, and they can do it by following the procedure, but that procedure is different. Now, if you see, the rule 12 is what they have used. Under this, a probationer is discharged on certain reasons, if they fail to pass the examination, if she or he is not suitable for this post, etc. So that's a general suitability. But there is another rule which comes in rule 11 of probation, that if there is a conduct, a specific allegation or misconduct which is unbecoming an officer, here they mainly refer to during the period of probation. If you do something unbecoming an officer, then there are certain rules need to be followed. But the act here is not during the period. That's a technical difference. That is something which need to be discussed in the court in a different way. But the question is it a general suitability to discharge under this rule? This rule is not applicable. You cannot discharge Pooja by using this rule because it's a specific misconduct, stigma is attached, and it's a dismissal. Natural justice is not complied. Article 311(2) of the Constitution is not complied. If there is any punishment, if there is a punishment for a specific misconduct, and if there is stigma, Article 311(2) of the Constitution need to be complied with. And in case of Pooja, not only that, you need to comply with Rule 11 of probation and Rule 8. In Rule 11, they are saying that if you need to do this, Rule 8 of All India Services need to be followed as a disciplinary proceeding. And after that, you also need to consult the commission. That's different thing. Commission, UPSC is against her, but the procedure is followed or not. Rule 11, not followed. Rule 8 of All India Service, not followed. Commission consulted, that's a different thing. That order is different. Okay. So let's get into the topic. Now, what will be the verdict? Court will say that we had to interfere here due to natural justice is not complied with, reinstate her. Article 311(2) not complied with, reinstate her. And Rule 11 of IPS probation not complied with. Rule 8 of All India Services not complied with. UPSC has not been consulted. This might have done, but the procedure is not followed. So she will be reinstated. Court will also tell that you can take fresh action by following natural justice, means give her opportunity to defend herself. Whatever evidence is against her, give it to her, allow her to defend. So that's what natural justice. You follow this 311(2), that's again natural justice only, and then you follow these rules, and it should be based on All India Service Rule 8, which is very difficult to follow and terminate her. Now, even in that case, still Pooja can escape from this for another 20 years. That's for sure. If you have a good lawyer, if you have the knowledge, she can another 20 years. What you can tell? Now, what you will do is, UPSC action also will be cancelled, quashed. Her candidature of, candidature. The candidature has been cancelled. That will also be quashed. then court will say you give her opportunity to defend herself, follow natural justice, and then take the action. Then what UPSC will do? UPSC will call her, providing natural justice. Then what Pooja need to do? Very simple. She can tell that my case is going on in the court, and if I come and try to defend myself, it is against my fundamental right that I am exposing myself. I don't want to give any evidence against me. It will prejudice the court. If I make any statement there, UPSC is against me and UPSC filed the case, and if I'm going to tell them about my evidences and everything that they can manipulate and it is against my fundamental right, I don't want to give evidence against me. And it will, if I do anything, it will prejudice the court also. So she never want to go to UPSC. And if she again move to High Court will also tell the same. It's against her fundamental right. Okay, so there are a lot of things which you need to understand. So 100%, I'm telling you, I'm betting on everything what I have, she'll be getting it back. Okay, so hundreds of judgments also I can show you. I told you already, Radhey Shyam Gupta, Purushottam Lal Dhingra, and then Shamsher Singh, so many others, and IAS officer VK Singh versus Union of India, Anup Jaiswal versus Union of India, Mahavir Singhvi versus Union of India, even Palak Modi case, which is a recent case. Mahavir Singhvi also is a very recent case. Okay, so let's get started. Now, the grounds for challenging the discharge. So, procedural non-compliance. I hope you understood that. So, what are the procedural non-compliance here? She has been discharged under Rule 12 of probation. That's a general rule which you cannot do in this case. If you need to do something in this case, it has to be on the basis of Rule 11. And Rule 11 should be followed by Rule 8 of All India Service. So Rule 11 of IAS probation, Rule 8 of All India Service, UPSC need to be consulted, Natural just 311(2) need to be complied with. So this is against the constitution. So judges have no option, the court have no option but to simply strike down the order, reinstate with all the salaries and everything, with the seniority. Okay. Constitutional violation, that's what Article 311(2) of the Constitution. Disguise punishment. See, order appearing innocuous, but actually being a removal order under Rule 1112. See, the order is discharge. Why they are doing that? Because, see, discharge and dismissal, there is a difference. If you're dismissed, normally you won't get any employment in the public sector. But if it is discharged, there is no such problem in taking any employment in public sector. So here it is a discharge, and in our terms we call it as discharge simpliciter. So order appearing to be innocuous, simple discharge order, but what it is actually, it causes significant stigma to her, okay, and it's a punishment. Did they follow natural justice? No, simple, that's enough for the court. Nothing else will be heard. Okay, natural justice violation, very simple. I hope all of you understood those cases. So she'll definitely get back. And if still anyone want to challenge me in this, I can bet on anything what I have. Okay, so I've seen hundreds of cases and I guide hundreds of them. Rule 11 of All India Probation. So a procedural safeguard is there. For that, Rule 8 of All India Services need to be followed. This is actually applicable in her case. And this is a challenge here. If this need to be applicable, they need to follow this first. That's why they have taken an easy route of Rule 12, that is simple discharge. It won't work in this case. That work in a different case, general suitability. I'll come to that also. So if she need to be dismissed, they need to first follow, 11, Rule 11. In Rule 11, they are saying you follow All India Service Rule 8, which is very difficult. Especially when you have a criminal case pending. So when you have a criminal case pending, how can I go and prove it to UPSC now? Because I have to cross-examine and I have to produce my evidence in the court, not to UPSC. What is my priority? Otherwise, the court will be prejudiced. Otherwise, it's against my fundamental right that I am giving evidences against me, which is not required under, that's my fundamental right. Okay. Now, grounds for removal, conduct unbecoming of a member. But there is a technical issue here that this happens if she is, doing something during the period of probation. But the same is actually what happened here. It is not during this period. There is a specific allegation. The entire case is about specific allegation. It's not general suitability. It causes stigma. Okay. Consultation of UPSC. This is what I mean by commission need to be consulted. Okay, now let's come to rule 12. So she has been discharged. There, if you are following rule 11, it is removal of service, removal from service or dismissal. This is discharge. This rule is applied. In which case, failure in final exam, not happen. Ineligibility or unsuitability, this is what they have applied. Lacking required qualities, this is what they have applied. But the question is, she was there in academy for 2 years. You were not checking her, lacking qualities and ineligibility and unsuitability of a probationer at that point of time. When this specific incident came, then only you are checking. That's the question court will also ask. I am not asking this. Court will ask, why you didn't check eligibility and unsuitability at that point of time? Now you are talking about all these because of specific misconduct. Is that proved anywhere? Nowhere it is proved. It's just allegations, right? Till the time, what is our rule? Even she also, I think, made in one public statement that till the time court is not calling her guilty or giving a verdict, you cannot, right? So non-compliance with the rules. In these cases, you can be discharged. And what has been done here? You applied this rule because application of this rule is very simple and you discharged her. But can you apply this rule in case of specific misconduct? No. Can it be applied in a general case? Yes. But when you have to assess, there are internal assessments and other things where the director finally, now you look at the assessments. Is there any mention that she is not eligible? Is there any mention that she is unsuitable or lacking required qualities of mind which is required to become an officer? Nowhere. Now this is there because of a specific misconduct. So that need to be proved. Okay. Now still, if anyone thinking that she won't get back, that's not the case. 100%. Okay, 100% she'll get back. It's just a matter of time. So she'll go to CAT first, CAT, then High Court, then Supreme Court. 100% from Supreme Court she'll get back. The thing is that it can be delayed. The more you delay, the better it is because you'll get all the arrears. Okay, and it can be done in that order. If you follow the procedure, it can be done. But can you follow the procedure when the case is there? It is difficult because it can prejudice. You can simply take an argument that it will prejudice the court. I cannot give I cannot come to UPSC and you are against me in the court case. So how can I come to you and give evidence to you? Simple. Now Shamsher Singh case, it is the same. See, it is again talking about specific allegation. If discharge based on inquiry into specific allegations of misconduct, inefficiency or corruption. Okay, any specific allegation, then Article 311(2) need to be complied with. Natural justice has to be followed. You cannot simply pass an order and discharge. General inquiry, see, this is what I told you. General inquiry means to understand whether the candidate is suitable or not. That's not the case here. Is it punitive in nature? Yes, it is punitive in nature. Is there stigma? Yes, there is stigma. There is one more point. There is something called as this judgment also there, motive versus foundation. So she has been dismissed, no doubt in that. Media, so she don't want to prove that. She want to prove that only, but it's been proved by media that she has been dismissed, right? Now the stigma is also there. Dismissal, media has been told. She just need to show one of the clipping to the court. That's it, right? Now motive and foundation, what's the difference is, if you are discharged for a reason, for something, okay, if motive behind the discharge is some allegation, okay, and then after that some inquiry and everything is conducted, then you need not need to comply with Article 311(2). But not only the motive, if the foundation, the very foundation behind the discharge is that allegation, then that allegation need to be proved. The 311(2) need to be complied with. All the rules and procedures need to be followed. So here, what is the foundation? What the foundation means, what's the real reason? Not only the motive. Motive is the beginning of the procedure. The real foundation here is that specific allegation that she did some manipulation. Whatever, she did some manipulation. See, I don't want to talk about what she did. Let's say she did X. And this X is the allegation. Is this the reason for, the discharge? Yes, then Article 311(2) need to be complied with. It could be corruption, it could be a murder, it could be a rape, it could be anything. X is the misconduct or X is a specific allegation. She has been terminated or discharged or removed or dismissed for this specific allegation. Article 311(2) must be complied with if there is constitution, if there is Supreme Court, if there is rule of law, and if we follow constitutionalism. Simple. Okay. So misconduct allegation, here it is misconduct, attracting Article 311(2). Now distinction in types of inquiries. General suitability, I have already made it clear. Specific misconduct, here it is specific misconduct that lead to stigma. That's a motive, that's a foundation also. If motive was the specific misconduct, okay, to an extent some cases will be considered. But if motive and foundation is a specific misconduct, you need to follow the rules. Okay, so these are repetitions. Grounds for judicial interference. Now, in this case, will the judiciary interfere? Of course, yes. Why? Article 311(2) is not followed. Natural justice is not complied with. Rule 11 of all in IAS probation, not followed. Rule 8 of All India Services, not followed. Commission is not consulted, of course, because after the procedure only, finally you need to consult the commission. This might have been informed by the commission, that's of no use. You have to follow Rule 11, All India Services. There are procedures in that, right? And then final step is the consultation to the commission. Unbecoming a conduct, yes, of course, it's if it is, now court will tell like this only, whatever she have done, if it is proved, it's a conduct unbecoming an officer and she must be removed from service. But then how? Follow Rule 11, follow All India Service Rule 8, follow natural justice, follow Article 311(2). That's how you do it. Can you do it by following all these when the case is pending in the court? That's what I bet you another 20 years, if her legal side is strong, no one can touch her. Constitution violation. I've made it very clear. Article 311(2). Rule violation. Rule 11(2) of the IAS probation and Rule 8 of All India Civil, 8 or 9, I'm confused with now, 2 PPTs. Rule 8 of All India Services. Okay. Article 311(2), natural justice. This is enough. Any one is enough. So I hope things are very clear. There is no point in further discussion. I hope I have made my point very clear. Now, if any one of you have any doubt, I don't know. Okay, I have told about the facts. Just think about it, and the case is over. This is it, and everybody is expecting that everything is over, but nothing is over yet. It's just a beginning. Order will struck down. Simple. Impugned order struck down. And the court will say procedural non-compliance. Procedure is not followed. What not followed? Rule 11(2) of all IAS probation. Rule 8 of All India Services. UPSC has not been consulted. Natural justice has not been complied with. 311(2) has not been followed. Now, the court will also reserve the government right. Now I am going to struck down the order, the court, but you have all the right to follow the procedure and take appropriate necessary action against her. You follow all the rules, give her natural justice, Article 311(2), 11(2) of the IAS probation, Rule 8 of All India Services, follow this, and then nobody can come to us. If you follow this and remove her, she won't come to us. Even if she come to us, we don't have any provision to interfere. But now we need to interfere, because these are rights which is guaranteed by the Constitution and also your rule when she joined the service. Right? These I've told you already, right? And there is a specific allegation of misconduct. Same as the case of Radhey Shyam Gupta, natural justice, inquiry is conducted. Termination procedure. See here, was there any inquiry? Yes. And termination is after the inquiry? Yes. And this is a sentence which will be used. I'll show you the judgments, that the inquiry is conducted behind the back of the officer. Officer has not been given any opportunity to defend, right? So, who all are the witnesses examined, which all are the documents perused, she don't know anything about that. How can you take such kind of action which will significantly affect her life till the end, having that much stigma, especially being a lady? So, inquiry conducted, evidence received, right? They got the evidences and they are saying that she did something. Whatever it is, she did X. That's why she is no more there in the service. So if she did X, who proved it? Only they know. There are findings arrived and pass the order. It is completely illegal. It's illegal termination. Okay, now Purushoth, this is a very important case, landmark judgment. 7-judge bench considered this case. And what the key issue here is whether there is of an official higher officiating post could be treated as punitive. Again, this is a question of whether it is a punishment order or not. Contractual, right? IAS probationer, unlike any other probationers have a right to post. Normally, when it comes to probationers, they don't have the right to post. Now, this is again very important. IAS probationers, IPS probationers, they have the right to post, provided they can be removed only by following either Rule 11.2 or 12 of IAS probation. Okay, and to do 11.2, to apply 11.2, there are other things. And in Pooja's case, only 11.2 you can do, not 12. If you need to do 12, it should have been done before when she was in the academy. If you are questioning her ineligibility, it should have been done during the time when she was in academy. Punitive action. If termination is founded on misconduct, negligence or inefficiency, it becomes punitive. And if it is punitive, there is stigma. And if there is stigma, it will attract Article 311. Right? So that's a land. This is the only one single case is enough. Anup Jaiswal case was based on this case. Anup Jaiswal argued only one thing in the court. Anup Jaiswal case is in 1984. IPS officer, IPS probationer was discharged. So he said it's punitive and immediately reinstated. Anup Jaiswal versus Union of India. And in 85, there is a case VK Singh versus Union of India. That's again an IAS officer got discharged. In that, he referred only two judgment. That is Purushottam Lal Dhingra, and the judge himself referred Anup Jaiswal case. And if you read the judgment, you will understand that there is a recent case of Anup Jaiswal again in the Supreme Court. I think Venkat Ram Iyer, very famous judge, and that judgment only referred, and VK Singh also reinstated. Okay. This is another. This is an IFS officer, Mahavir Singh. The recent case, same. See, case background, he challenged again, it is punitive. So what Pooja need to do? She need to tell that it's a punishment. She need to tell that I have stigma. She need to tell that it's a dismissal, not discharge. That's it, nothing else. And court analysis, examine whether termination was based on unsuitability or misconduct. Now the motive is important. So I've told you already about motive and foundation. Final ruling, court held the termination was not punitive. Punitive. Was punitive based on, but again he is reinstated. Court held that it is punitive. So some PowerPoint mistake. This case is also went in favor of the probationer. So I have given you three cases, one IAS, one IPS, one IFS. What is the IAS case? VK Singh versus Union of India. IPS, Anup Jaiswal versus Union of India. IFS, Mahavir Singhvi versus Union of India. Apart from that, Shamsher Singh case and Purushottam Lal Dhingra, Radhey Shyam, hundreds of cases are there. Palak Modi, very good example for this case, especially. Anup Jaiswal. See, now the question is, okay, you are saying it is discharge and simple and other things, but is there any hidden punishment? Court will also look into this. Is it a hidden punishment? Now, in Pooja's case, we don't want to prove anything. Media have proved everything. It's a punishment, it's a dismissal. She did that, she did this, and because of that only this order has been passed. So she even don't want to prove anything. Just one news clipping is enough to tell the court that I have stigma. Look at this. It's over. Natural justice, okay, same. So I hope this is very clear now. There is no point in, fairness need to be there, but she has not been given any opportunity to defend herself. Explanation is called for. So what's the purpose for that? You need to allow her to defend her case. You need to show the documents that you have to prove that she did X violation. Procedure need to be followed. In this case, what are the procedural irregularities or non-compliance? Article 311.2 is not complied with. Rule 11.2 need to be followed, which is not complied with. All India Service Rule 8 is not followed. UPSC is not consulted in the proper order. Okay, and natural justice, of course, is not followed. Natural justice, So court will look beyond the form and substance of the order and will come to the conclusion, is it punishment? Yes. Then it will structure. Court have no other option. Don't get emotional. You cannot get emotional. The judges cannot get emotional. Even the judges also know she might have done X misconduct or violation. It need to be proved in the court of law. Right? So there is a procedure. Rule of law is there. That's it, guys. Thank you so much. I hope now the confusion is over. I've made it very clear. You might have heard a lot of news, but no one is very clear about what is actually happening. Everyone is thinking that she is dismissed and it's over. So everybody is talking about dismissal. What she need to do is she need to tell the court that it is dismissal. But everything is already in the air. She is dismissed and she is dismissed for that. She did this, she did that. She just need to prove only 2-3 things. It's a punishment. Yes. A hidden punishment, you can say. She has stigma. Now, can the court deny that she have the stigma? Just show one of the news clipping. That's enough. And she need to prove anything beyond this to show this as a dismissal. No. So, thank you so much, guys. I hope you understood things that I have discussed. See you in the next video.